Hi, and welcome to another F&D presentation. Today, we're continuing on with our It's a Great I.D.E.A series. We're going to be discussing the power of us, parental participation. So welcome. I'm glad that you're here today. My name is Sassafras Middleman, and I am a parent trainer here at the Family Network on Disabilities. A little bit about us. We are a nonprofit. We're a 501c3. We actually receive our funding from the I.D.E.A. We are the state's parent training and information center. So parents can come to us to get information on I.D.E.A. and on IEPs and everything ESE related at no cost to them. We are family driven and family centered. What we mean by that is we were started in 1985. A group of parents came together, wanting information, resources, wanting to know what's legit, what's not, what can we do, and out of that was born the Family Network on Disabilities. And we're happy to help walk you guys through, to teach you I.D.E.A, to help you be a better advocate in the IEP process, because we know what it's like. We are truly powerful. As parents, we see our kids in numerous environments. We are full of what they call anecdotal evidence. And it is our greatest privilege to be able to teach you, fellow parents, how to best advocate for you and your kiddos. We do not act as attorneys, doctors, or mental health professionals. We instead get you the up-to-date information, resources, and the supports that you need to be the best advocate that you can be. So moving on to our topic for the day, we're going to be talking about the Individuals with Disabilities Education Act, which of course is our nation's federal special education law. Nothing can be passed by the state's legislation that would supersede the I.D.E.A. Nothing can be implemented by the Florida Department of Education that would supersede the I.D.E.A. And of course, nothing can be implemented at a school district or school level that would be in violation of the I.D.E.A. So this series is all about breaking down the 6 major principles of the I.D.E.A. So if you have hung in with us this far, we have gone through a free and appropriate public education. We talked about the necessity for appropriate evaluations. We talked about a little bit about how to demystify the individualized education plan and how to better prepare and brainstorm as a parent. We talked about the least restrictive environment and the importance of inclusion, that children with disabilities be surrounded by children who do not have disabilities. And today we're talking parental participation. So the last topic we have coming up next is procedural safeguards. And that is, of course, our alternative dispute resolution process for special education. And I know that's a topic that a lot of us parents don't really know a lot about when we're first starting out, but we are very happy to talk to you about what happens when there are disputes or whenever, you feel like there has been an act that was not correctly implemented. So there are procedures for that, and we are going to get into them. But today we're going to be talking about us, parental participation. So the evidence is clear and consistent. When schools and families work together, learning outcomes improve. So we know that children's attitudes towards schools improve, their social skills and behavior improves, and the likelihood that they will take more challenging classes and pass them go up. So this holds true across all socioeconomic backgrounds, all, colors, races, ethnicities, religions, educational backgrounds. We know that when the parents are heard and part of the process, it has better outcomes for that student. So one of the I.D.E.A's founding principles is the right of parents to participate in educational decision-making regarding their child with a disability. The law is very, very specific about what school systems must do to ensure that they have the inclusion and consent of parents and that they have the opportunity to participate at every level, including the IEP meeting where we come up with that individualized plan for that student. Parents have the right to participate in meetings related to the evaluation identification, and educational placement of their child. They have right to participate in meetings that have anything to do with the provision of a free and appropriate public education for their child. Parents are entitled to be members of any group that decides whether their child is a child with a disability. So that initial evaluation and that decision whether they get qualify under one of the 13 qualifiers. Parents are entitled to be members of the team that develops, reviews, and revises the Individualized Education Plan, or that IEP. And you have the right to be involved at virtually every step along the way with your child's identification of having a disability and the services that that they will need through the schools and receive because of that disability. So again, parent notification, prior written notice, prior written notice. So we keep talking about this because this is an extremely important part of the process. This is the communication, the official communication required by I.D.E.A. so that parents know what is happening, what to expect, who's going to be at this meeting, and that guarantees their right to participation. So prior written notice refers to any of the message that you receive from the school system at specific times. So it's any time, any with respect to your child's identification as being a child with a disability. So that initial evaluation and placement, your child's evaluations, their educational placement, and the school's provision of a free and appropriate public education to your child. So, i.e., let's break this down into layman's terms. Anything that has to do with any of those sections on the IEP, their evaluation, their eligibility, services, related services. So think all the OTs, the behavior, the physical therapy, access to tutoring, transport, all of that. Anything relating to any of that. And of course, placement of your child. All of those are to be determined by the IEP team, which you are inherently a member of. So prior written notice includes notifying you of upcoming meetings far enough in advance so that you have the opportunity to attend. You can juggle the dates and the times. And even if something comes up close to the established time, you have the right to inform them that for whatever reason, you're suddenly unable to attend and you're not waiving your right to parental participation. So that is embedded in the I.D.E.A. So the school is going to tell you about upcoming meetings. This prior written notice, it has to include the purpose, the time, and the location of the meeting. Also the format. Is it going to be in person? Is it going to be virtual? Is it going to be on the computer? Or sorry, teleconference. So it has to indicate who's going to attend that meeting. So it has to have everyone that's going to be on that meeting. It's also going to give you the opportunity to say if you want to bring somebody to that meeting. And this is your opportunity to now give the school prior written notice that, you agree that this meeting is happening at this date and this time at this place and this format. And we're going to discuss this and all these people are going to be here. And it's your chance to say, hey, I'm going to bring my, when my daughter was younger and we were talking about behavioral services for her, she was receiving therapy through a private behavioral clinic in town. And so when they were discussing her behavioral needs in this meeting, I thought who more appropriate than to ask my behaviorist to attend the meeting. And she was able to do so. And so instead of listening to it just through my vantage point, which is important, but I was able to bring somebody else who had that professional observation and had done evaluations and had already had an existing plan of care and knew the child's behavioral status very, very well. And so that is all of the prior written notice. So there are some meetings that don't require parental notification. So informal or unscheduled conversations between school staff can happen and do. Conversations on issues about teaching methodology, lesson plans, and the coordination of services, or the preparation and activities of school staff that are developing a proposal that will later be discussed at that meeting. And here's a caveat to that. If they're going to propose something and they come up with a proposal based on that meeting, they'll have to list all of the considerations that led to them coming up with that proposal, as well as other ideas that they had and why they decided that those weren't very good options for your child. A free and appropriate public education. That is what we are guaranteed. And parental notification has been embedded in that concept since they came up with the 1975 law, Handicapped Education for All Children. So we are integral to this process. No longer can they, have meetings about our children. Can they tell us, where they're going to go, if they're going to stay with us, if they're going to be in a residential placement, if they're going to have an education at all? These are not things that happen anymore. And so it's well established that parents are the ones who want to take the lead on this, and that we have every right to participate as valid members of the educational and decision-making team. So we are going to review that prior written notice one more time because it is very, very important. So we parents have to be given prior written notice anytime that the school is proposing to initiate the change of identification and evaluation, educational placement, or the provisions of FAPE to your child, i.e. those services, related services, accommodations, extra personnel, transportation, all of that stuff would be considered the provisions of FAPE to your child. So this is if the school is proposing it. Now, on the other hand, as parents, we have the right to request things, right? We can request placement changes, identification changes. We can request evaluations the same as the school can propose them. So they also have to give you prior written notice in response to your requesting either a change in the identification and evaluation or the educational placement of your child. They have to tell you why they are refusing to take action, or if they agree to it, why they are agreeing to it, and how that will take place. So prior written notice is meant to give parents a full explanation of what the school system is planning or proposing to do, so that parents have the opportunity to meet with the school personnel and have their points already, because it's prior written notice. So you have time to think about it before you attend this meeting. Whether you agree, whether you want to provide input, whether you disagree. That's why this is so important. It's sometimes we get calls from parents and they're not sure why the meeting is being held. It is of the utmost importance that we know why this meeting is being held, whatever it may be. And that the reason for that is because we want to come in prepared. We have thoughts and observations on whatever it is that they're going to propose. But we, just like everybody else, need time to gather our thoughts and get them, bulleted out or rehearse them or however, so that it's cemented and you're ready to participate in that meeting. So again, I.D.E.A requires prior written notice anytime, that they are proposing to change anything within ESE services, or they are refusing it when you're requesting it. So that prior written notice always has to include a description of the action proposed or refused by the school, an explanation of why the school proposes or is refusing that action, a description of each evaluation procedure, assessment record, and report that the school used to come up with any decision that they made, whether it's that they're proposing something or they're refusing something you're proposing. A statement that the parents of a child with disability have protection under I.D.E.A's procedural safeguards. Again, we're going to talk about that being the last tenet of the I.D.E.A. And then sources for parents to contact to find help in understanding these provisions, like us, your parent training and information center. A description of other options that the IEP team considered and reasons that they were rejected. and any other relevant factors that they use to come up with either their proposition or to refuse what you're proposing. More about prior written notice. So I.D.E.A requires that it be written in language understandable to the general public. We understand that you're not lawyers and we understand that you're not special educators. We as parents need to be able to go in there and read those documents and understand them in order to give informed consent, in order to truly participate in the brainstorming that the IEP meeting is supposed to be. So it also has to be provided in the native language of the parent. So do not be shy about this. Also, if you have any other disabilities yourself that need accommodation, I had a parent one time that they were trying to do a teleconference call with, and she had hearing problems and was like, this is not going to work. Like, I need to be able to read people's. So speak up, speak up. It has to be in your language. You have to understand it. So even if it is in your language and you don't know what you're reading, stop everything because it's critical that you do. Ask those questions. Get on your phone and look it up. Say, I need to take a break. Or if it's on the prior written notice and you're not understanding it, give us a call and we can help you before that meeting, give you a chance to understand what's happening and to have your own contributions. So at every IEP meeting, you will get a procedural safeguards notice. Now, they have to give you one of these once a year, even if you have it a virtual meeting or a teleconference meeting. It can be sent to you electronically or it can be handed to you hard copy, but they are required to give you your procedural safeguards notice at least once a school year. So you will also get your procedural safeguards when your child is first referred for that initial evaluation, or if you ask your child to be evaluated. When the school receives due process or a hearing complaint, when the school system receives the first state complaint, when your child violates a code of the student conduct and is subject to a disciplinary charge of placement by the school, and when you ask the school to provide them. So you can ask them at any time. So it's just a piece of paper. It's all written out in very boring, long text. A lot of parents are usually kind of frazzled by the end of these meetings and it ends up God knows where. We talk to a lot of parents who don't understand procedural safeguards, and that's okay, but that's kind of our mission to change that. So again, that's going to be the next session in this series, and it's a great one because dispute is natural, disagreement is natural, and there are procedures within the I.D.E.A for parents to pursue that. So we look forward to that one. So this is one of our one pagers. It's a great example. This is about the rights of parents to participating in meetings regarding their children with disabilities. We have one pagers like this on every ESE topic you can imagine. They are very helpful. You can go there and start looking through them, start thinking about them in relation to your child, meetings you've attended. If you have questions, give us a call. We'll be happy to answer your questions, to give you more information, whatever you need. So remember that we are critical in the brainstorming and the advocating for our child. And these IEP meetings, it should not just be where you're being read a document and you don't feel like you're participating very much except for to sign the end. This is actually a time where you're supposed to be participating. I always encourage parents to ask for that copy of that IEP a week before the meeting. Know what it's on, know what they're thinking. So that way, if it's missing something, maybe, your child has had a new development that's not covered, and you want to make sure it's addressed. Maybe, that there's something that they really need to work on. And so you have a contribution for goals. it's important that we are able to participate. And so this is something that has been guaranteed to us, like I said, since 1975. So if you need any help to be the best advocate that you can be, know that we're here and you're never alone, and that resources don't cost you anything, and we're happy to do it. So that brings us to the end. There is no evaluation. Just a little bit more about F&D. We are the Family Network on Disabilities, and I am in the Panhandle with Poppin, parents offering parents information and networking. But we do, in fact, cover the whole state with the Parent Support Network and Parent Education Network as well. We are everywhere. We are on TikTok, Blue Sky, Instagram, Facebook. Our website, where you could get more of those one pagers, is fndusa.org. It is an amazing, amazing resource. You can download them, you can share them, you can whatever, there's just so many. There's so many good resources there. You can reach us at 1-800-825-5736, or you can use your camera on your phone to actually open my purple popple there, and you can get a contact with me directly. So thank you for your time. I hope that you stick with us. And the next section will be those procedural safeguards. So what do we do when there's a problem? What do we do in times of dispute? Well, I.D.E.A definitely has the answer for that too. Thank you for your time. I really appreciate it. All right. Thanks.